Good morning, everybody. This is Don Bautista, the Executive Director of AC Friends of Court. As you may be aware, AC Friends of Court continues to serve the public in completing legal forms in a virtual setting. And what we've been saying all along is every day when clients ask us for help, there is quite a palpable sense of stress when these self-represented litigants ask and speak to us to see if we can assist them. So for the public, our heads of courts and tribunals are generally unseen, they're unheard, except of course through the decisions that they make. This series allows them to speak unfiltered. And this series of one-on-one interviews is an opportunity for our guests to inform the public of their planning and the thinking behind their planning, to tell the public how they're working to even the playing field, and third, to share their reflections on what they're learning now that might be important to continue after the pandemic. Our guest today is Chief Justice Wagner of the Supreme Court of Canada. They've agreed to share with you what they are doing to help self-represented litigants, the public generally, as well as to assure people that even if they are coming before the Supreme Court of Canada without a lawyer, that they will still be able to participate in the courts in a way that is fair. Good afternoon, Chief Justice Wagner. Before I ask you my 4 questions, I'd like to give you an opportunity just to address the public, British Columbians.
Well, thank you so much. It is really my pleasure to be with you this afternoon. And first of all, I'd like to thank you and your organization and for taking the time and to have the commitment to inform the Canadian people about the justice system, about what's going on in the justice system during this pandemic. I think that your efforts and your time to inform the public is very important. So thank you for that. I'm also pleased to take part in this timely and important conversation. I may have some preliminary comments before you maybe have questions for me. You know, like any counterparts around the world, Canadian courts have taken significant steps to deliver justice despite our courts being physically closed, and our court is physically closed until September. It is undeniable that access to justice and the rule of law cannot tolerate any other option. At the Supreme Court of Canada, we hear cases of national importance that originate from all over the country, which means that the parties and counsel are located from coast to coast to coast. Our court has long had the capacity to use video conferencing technology during hearings on an exceptional basis. The difference now is the scale at which we must deploy such technology. That is a challenge we have risen to. In early June, we have heard 3 appeals and 1 leave to appeal application via video conference. We have leveraged technology to ensure that translation will be available to meet our duty to deliver justice in both official languages. On a day-to-day level, we have moved to electronic filing of materials, and our entire organization, including judges, have adapted to working from home as we continue to render judgments on reserved cases and applications for leave to appeal. Changes like these and many more are reflected at every level of the Canadian justice system. The federal court has recently scheduled 40 hearings to take place via the online platform Zoom. And for many weeks now, our appellate courts across Canada, including New Brunswick Court of Appeal, the Manitoba Court of Appeal, and the Court of Appeal of Ontario, have proceeded with hearing regular appeals via audio or video conference. When the COVID-19 crisis first hit, many Canadian courts initially responded by allowing only urgent matters to proceed, via remote hearing, while they develop plans to implement broader uses of technology to proceed with certain regularly scheduled matters. This considered approach, in my view, reflects the profound commitment of all actors in our justice system to ensuring that our courts provide accessible justice that advances procedural and substantive fairness. One of the most important things we must keep in mind as we continue to navigate this period of uncertainty is that the success of our justice system, and indeed the rule of law, depends on public confidence, on public trust. First and foremost, the current situation is simply a catalyst for change. It is not necessarily an assurance of change. We must see this as an opportunity to critically reflect on the status quo. This means that we cannot simply view the changes to date as temporary measures to bridge us back to normal. They must be seen as opening the door to imagining a new normal. They must be seen as opening the door. Indeed, many of the challenges that were present in the status quo have now been compounded with increased backlogs resulting from adjournments and adjustments of filing deadlines. Canadians have an expectation that our courts will find ways to address these backlogs swiftly. Further, Canadians have now come to see that effective alternatives to in-person hearing are possible. And I would endeavor to guess that justifying removing them as an option will become increasingly difficult. This is a forced pilot project of sorts. This means that the data and feedback we generate from this period should be gathered and reflected on, and we should emerge with concrete plans to move forward. This opportunity has not been overlooked in Canada. In addition to the many local initiatives, there are two nationally focused initiatives which are aimed precisely at reflecting on the challenges we are facing. Earlier in June, I established a National Action Committee with the Attorney General of Canada to provide national leadership and coordination on the transition back to full operation of our courts. In April, as you may know, the Canadian Bar Association established a task force to address justice issues arising from COVID-19. The task force's mandate includes considering the lessons from this crisis to make the justice system more effective and prepared for the future crisis. These initiatives recognize that while the circumstances we find ourselves in require quick and decisive action, our actions must be coordinated, well-reasoned, and responsive to the realities in which the justice system operates. We must be open to considering alternatives. However, we must remember that confidence in our justice system relies not only on justice being done, but also on justice being seen to be done. To me, this means that we must take concerns that are raised by litigants and other members of civil society about transparency, privacy, and procedural fairness seriously. And we must critically reflect on the broader function that certain features of our current system carry out. This means letting go of some traditional ways of working which do not serve us well. This also means recognizing that sometimes efficiency and accessibility may not be perfectly aligned. Thank you for your attention. Now I'm willing to answer your questions.
Thank you, Chief Justice Wagner. Before I begin with my first question, I wanted to take us take take go back to 2017, just as you began uh, your tenure as Chief Justice, and I recall receiving notice that moving forward, judgments will be done in plain language. Can you share with us the thinking behind that?
Yes, I would appreciate to do that because, access to the court, access to justice is not only access to a courthouse, it's not only access to a judge, it's also to access to information. Access to justice is access to information. And when I became Chief Justice, one of my goals was to make the court more accessible. And in doing so, you can do many things. You can do what we've done back in September of last year and go to Winnipeg to sit for a full week. We heard 2 cases, and we met with the students of high school students, the 9 of us in 9 different schools. We met with the indigenous people representatives. We met with the Métis people. We met with the Francophone community. We met with the law school students. So it was a full week of a reaching out exercise. And we sat for the first time in our history outside Ottawa. So that's one way of doing it, reaching out. But there's another way also, is to give information. And when I became Chief Justice, we decided to issue what we call now the cases in brief. So on one page, we decided to summarize the legal issues in accessible terms, terms that everybody can understand without having any expertise in the legal world. So the cases in brief were very popular. And they are still very popular. And at first, it was designed to be read by the citizens of this country. But we learned quite rapidly that it was used by other judges, by lawyers, by the media. So it has a very useful purpose, and I'm very happy with that. So in terms of access, in terms of openness, that was one way to do it. We have other initiatives like the year in review. I don't know if you had the chance to look at it. It's the annual review of our activities for the last year. What are the cases that were heard? What activities the judges were involved in, and so on and so forth. So that's part, again, to access to justice, because it gives and provides information to the citizens of this country to allow them to know us, to know the judges, to know the courts, how we do things. Because how can you have trust in somebody that you don't know? You have to know, and you have to provide the knowledge. And that's why, since I became chief, I'm very proud, with the support of my colleagues and the staff, we have a good personnel at Supreme Court, we're able to initiate those initiatives.
Well, on behalf of all the British Columbians, of course, we look with a lot of envy that you chose Winnipeg instead of Vancouver.
And one day we'll go to BC.
Yes, and if you do, Chief Justice Wagner, I hope you will consider speaking in front of our volunteers to talk about access to justice live.
It will be my pleasure, sir, because, when I became a judge of the Supreme Court back in 2012, my first conference, my first speaking engagement was in Vancouver for the first summit on justice, which was established by the then Justice Minister. And that was my first presence in Vancouver.
Thank you. I do look forward to it, and it's probably a good reason to hope that the pandemic will go away soon.
Yes.
So in going back to your 2018 speech at the 7th National Pro Bono Conference, you opened it by telling us that the more things change, the more they stay the same. And now when we look at the pandemic, what lessons have you learned from it? And I'll bet it's been just, a couple of months, but are there lessons that you and your officials have learned that you will carry, how you can better carry out your responsibilities to Canadians?
Yeah, I think that's right. I think that this terrible pandemic, it's terrible on many levels in terms of health, of course, and moral injuries also, and economic injuries, and all type of problem. It's a terrible crisis. But through this crisis, if there was some silver lining to the crisis, is the fact that people now realize that there is a possibility to modernize the courts, and not only to bring money into the court, but to modernize the court, to do things, to release judgment, to release justice in a different way. And I think that this pandemic gave us this opportunity to realize to what extent we need that transformation, because we have to remember that even before the pandemic crisis, our justice system in Canada was in need. It was underfunded. It was the same in every province of this country and every country where the rule of law governs, because the governments invested in health, invested in education, and that's the right thing. I mean, it was the right thing to do, but the justice system was not taken care of. And you know, we lacked. There were not enough judges, not enough courthouses, not enough judicial resources, not enough money in new technology like e-filing, for instance. And so that was before the pandemic. Imagine what the pandemic brought is the realization that we are in need of investment, not so much for new courthouses, not so much for new judges, but for new investment in new technology to make sure that justice could be delivered without having the person to be present into the courthouse. And I think that's the main difference from now and before the crisis. And I think that everybody now realizes that we can deliver justice in a different way, more economical on the long run, and safer for the citizens and the lawyers and the judges. And I think we should take this opportunity to make sure that that will stay in the future and that will not be temporary.
Thank you, Chief Justice. So you talk about technology. From our view, because we're frontliners, we've always taken the position that technology should not be a hurdle. Now, the Supreme Court of Canada has been accepting e-filing, but I can think of a lot of our clients who, prior to the pandemic, relied on public intermediaries like libraries to get their e-filings done. As you know, libraries and community centers are closed. So this presents a problem that people are not able to access a computer in a safe manner. And so what is your thinking with respect to that? Because, you know, given what's going on with your courts.
Yeah, well, there are differences between provinces and differences between the courts as well. But I think you're right. I think that every citizen in this country should be able to present his or her case before any courts in the country, whether it be by e-filing, so having the means, you know, the computer, having the means to file the documents, or being able to file physically the paper, the material paper into the court record. So I think we should make sure that everybody can do either one of those alternatives. You know, at the Supreme Court of Canada, of course, it's not complete yet, but when I became Chief Justice, I gave instructions to my colleagues and my staff to put a lot of emphasis on e-filing. We must complete our system so that everybody in Canada could file a document or proceeding or notice by computer. And that will be able also to work without paper, to be paperless. And it's not a dream. I think we can do it. We're almost there. And so we're working very, very hard since I became chief to make sure that it happens within a reasonable delay. I can realize that in other courts, it may be a different story. because at the Supreme Court of Canada, like in Court of Appeals, for instance, we don't hear witnesses. There's no filing of evidence during the hearing. There are filing of documents before the hearings, but not during the hearings, which is not the case before the trial courts. And that's where justice is delivered at the first place. You know, where witnesses come to court, they give testimonies, the lawyers or the persons will file documents. So that's where the challenge is, the real challenge is. And I think that that means that every stakeholder must assume its responsibility. In other words, the justice departments in every province should make sure to invest and support the new technology, to make sure that everybody would be on the same level to be able to file documents or any piece of legal proceedings by e-filing. So it takes the cooperation of everybody, but I think that at the present time, I think that everybody realizes the urgency to do it, which may not have been the case prior to the pandemic crisis. Now, that's why I think we should take this opportunity and not postpone it, but not to put it in the future, but to take it right now to make sure that we invest at the proper place. And the proper place is technology, no doubt about that.
Let me move on to my third question. Because you've alluded to it earlier in our conversation, for the public, every case, their case is very important to them. But oftentimes, trying to get lined up to be heard is a barrier into itself. And you said so earlier today when you said, you know, what is considered to be urgent and non-urgent, you know, it's hard to try and explain that to the public, how courts will view what is urgent and non-urgent. Do you want to share with us some of your views on, you know, you've alluded to it, procedural fairness and all these things to just assure the public you're alive to this?
Yeah, it's, I think the judges across the country, and I'm sure you won't be surprised to hear that I'm very proud of the judges across the country. I think we have a very good bench. We have judges well-trained. As a matter of fact, judges from the foreign countries come to Canada to be trained because NGI, we set up some training courses. So I'm very proud of the judges. And across the country, they are very sensitive to those issues. And I don't know if you knew that, but at the Supreme Court of Canada, about 20 to 25% of all our leave applications, and you know we receive between 500 and 600 leave applications per year. 20 to 25% of those are filed by a self-litigant. And they don't know by definition the rules and the format and the way to file documents. And instead of simply discarding those applications, we help them. So that's one way, you know, and it takes a lot of time from our staff to communicate with those people and to tell them that you should file in such a way and so on and so forth. So it takes a lot of time, and I think it's part of our mission also, so that everybody should have a chance to present their case. And I think that a case may not be urgent, but it's still important. And up to now, of course, because of the pandemic, many courts, the trial courts essentially, were not able to address all those other cases that may be important but not urgent. But now I think they are doing it. I think that more courts will be open within the next few weeks to make sure that using technology, even the non-urgent cases will be dealt with very rapidly. So, you know, I'm chairing the Judicial Council, and so I have the chance to talk to many judges across the country in every province. And I can tell you that all those judges and the chief justices in each province are very sensitive to those issues, and they are taking steps to make sure that even the non-urgent cases will be dealt with as soon as possible.
Now, you mentioned procedural fairness, and I wanted to bring up Pintea because you were part of the crew that basically looked at the case in itself. And it's been, I guess, 3 years now since the decision was handed down. So 2 questions, Chief Justice Wagner. Number 1, personal reflection. It's been 3 years. From the time you heard the arguments till now, what do you think? How are we doing? And secondly, are you seeing more and more self-represented litigants citing Pintea, asking judges to grant them or just alerting the judges that they are self-represented and they're asking to be treated fairly? So those are my 2 questions.
Well, I'll try to answer that in one statement. I think that the question of self-litigants, when I became a judge in Superior Court back in 2004, we could see sometimes the self-litigant come to court in family matters, sometimes in criminal matters, but that's about it. It was really, very rare, but it became very popular with the time passing by. When I joined the Court of Appeal, I said to myself, well, the self-rep is linked to the trial judges, level, and not the Court of Appeal. But no, there were every week a self-litigant coming to the Court of Appeal, arguing his or her case. When I joined the Supreme Court of Canada, I said to myself, well, Supreme Court of Canada, there won't be any self-litigant before the court. Yes, as I mentioned to you, 20 to 25% of the leave applications. And we heard 2 cases argued by self-litigant. So it's there to stay, I would say, because there are many reasons for people to represent themselves. Of course, the money-wise, the monetary aspect is important. In other words, there are many people who don't have the means to hire a lawyer to be represented. That's a fact. But there are a small portion also of people who believe that they would better defend their case if they would do it themselves. And that's why I think that the law societies, that the other stakeholders in society have a responsibility to convince the citizens of this country that they would be better helped and defended if they would refer to legal services, legal aid, or other type of services. So I think that there are two ways of looking at it. One is to help the self-litigant to make sure that he or she has her day or his day in court. But at the same time, I would hope that with the help of everybody, the help of all stakeholders, that every person who comes to court will be accompanied by the best possible lawyer. And so that, whose knowledge and expertise should be the answer. So I think that we should help those who cannot afford lawyers. I think that governments should increase legal aid budgets to make sure that every citizen has access to legal aid. And but at the same time, I think at the end of the day, I would hope that more litigants would be represented by experts.
So speaking of which, that leads me to my 4th question. Lawyers are very powerful insiders. Through their regulators and bar associations, they can essentially tell the Supreme Court what's on their minds. And flipping that the other way, that makes it easier for the courts to tell them what's on your mind. And this became very, very obvious when COVID hit us, that there was not a day where some level of court, from the trial courts all the way to the Supreme Court of Canada, they were issuing notices. So there was a lot of back and forth between them, the law societies, just to make things work. But for an individual, a self-litigant, they don't have that kind of pipeline to the Chief Justice of Canada. What do you say?
Well, I think they should have trust in the Supreme Court of Canada, because the Supreme Court of Canada will help any individual, any self-litigant who has a valid course, a valid recourse to, and a valid case to proceed before the Supreme Court. That's what I would tell them, because that's reality. As I mentioned to you, it would be easy for us to say to those self-litigants who don't have the proper knowledge of the formalities and the regulations, and to say, well, you know, as long as you don't file your documents the proper way, we will not hear you. That's not what we do. What we do is we'll help them to make sure that their case be presented. That doesn't mean that these people will be successful, because of course, at the end of the day, we have to decide on the law and the application of the law to the facts of the case. But at least to give the chance to those people to have a chance to at least argue their cases, at least for the leave application, to show that they have a strong case to argue, given our regulations. And our regulation, of course, is that to go to the Supreme Court of Canada on the merit, you have to show that the legal issue is something that is of national importance, of public interest. So we rely on the Court of Appeal to decide on the other topics, and the trial courts. So it's not easy to go to the Supreme Court, you're right. But it's not easy, not because people are self-litigant. It's not easy because there are very few cases that would justify the criteria of national importance.
Thank you. So I have a sense of relief that you have not said anything in French. But Chief Justice Wagner, I wanted to just sort of quote your quote, because when you were here in Vancouver at the 7th National Pro Bono Conference, you cited Honoré de Balzac, and you said laws, what he said, the laws are spiderwebs through which the big flies pass and the little ones get caught. If you apply the lens of the pandemic, is it still the same?
I think, yeah, I think there's an improvement, and I'll tell you why. I think that people realize much more today the need to make sure that everybody has access to justice. And it took that crisis, unfortunately. I thought that there was a crisis before that, not health-wise, but there was a crisis before, because, you know, we released Jordan in 2016, you will recall, because of the delays in criminal matters. You know, it took some 5-6 years before an accused had his trial. So it was unacceptable. And we released Jordan in 2016. And it made a big difference, because starting in 2016, governments then decided to invest in the justice system. The law societies and the lawyers reacted as well, saying we have to change our way of doing business, our way of practicing law, so to make sure that there won't be any additional delays. And so there was an improvement. And it took this pandemic now to make sure that people realize the need to maintain for the future the access to justice through new technology now. So I think I'm hopeful and I'm optimistic for the future. even if we are living through a terrible crisis at this time.
I am hopeful that the impetus to keep forging ahead continues. I have a sense that, you know, people have moved from like our justice stakeholders have moved from sort of triage to transition, but it's kind of slowed down now. And I just worry sometimes that complacency has begun to set in again, that the urge to go back to the old ways would make a difference. I can tell you from our lens, just even a simple commissioning of an affidavit, virtually, it took one lawyer, one paralegal, an hour each with the self-litigant. And that assumed all three parties had a printer, a scanner, and Adobe Acrobat.
Yeah.
That's three things.
I understand.
And I feel so bad for them, because even after that, one of our volunteer managers had to spend another hour just putting everything together for one 10-page affidavit.
Yeah.
And yet, when you think about it, is it really necessary still? And so I'm looking for these changes. And I even think that these are low-hanging fruits that I think we are capable of moving past. But I'm not sure if there's an appetite from the leaders to say, well, that's the old way of doing things. Do we need to continue? So I wanted to share that with you, because not a week goes by where there's a self-litigant who we need to help swear an affidavit virtually. It's tough.
I understand.
It's
We should not take anything for granted and keep fighting.
Thank you. Well, Chief Justice, I am aware of the time. I have run out of questions, but I did want to leave you with the opportunity for final words.
Well, thank you so much. The only message I could give to you and to the people who are listening to us is that they should be hopeful, they should be optimistic, because I believe that we're on the right path, given this terrible pandemic crisis. We're on the right path to make sure that access to justice be maintained and supported and improved. And that's the only way that will keep our people, our citizens, that will keep them in trust with our system. And at the end of the day, it's a question of democracy. So it's a question of liberty. So I think it's worth fighting. I thank you very much.
Thank you very much. Merci beaucoup, Chief Justice Wagner.
Merci à vous.
And on behalf of all the British Columbians, please take care.
Thank you. You too. Be safe.
Goodbye.
Bye-bye.